Good evening, everyone. My name is Lonnie Rice III, and today we will be diving into the world of understanding trademarks and copyrights. Now, this is the Entrepreneur's Toolbox presentation for partial credit in ENT 630, Entrepreneurial Growth, and Dr. Bethany Davidson's class. And with that, let's get right into it. Now, first, a little introduction on trademarks and copyrights. Now, trademarks and copyrights are essential components of intellectual property law, designed to protect the rights of their creators and businesses. Now, together, trademarks and copyrights play a crucial role in fostering innovation and creativity, encouraging individuals and businesses to invest their time and resources into developing unique products and services for the customers. Now, understanding these forms of intellectual property is vitally important for anyone involved in creative industries, or in our case, entrepreneurship, as they navigate the complex landscape of rights, protections, and potential infringements on those rights. Now, let's take a little bit deeper dive into trademarks. Now, trademarks serve to identify and distinguish goods and services in the marketplace, providing consumers and customers with assurance of quality and origin. They can include brand names, logos, slogans, even sounds and colors in some instances associated with the brand. Now, by securing a trademark, businesses can prevent others from similar marks that could confuse customers, thereby safeguarding the brand's identity. Now, let's look at some purposes of trademarks. First up, brand identification. Trademarks help consumers identify the source of goods or services, distinguishing them from those of their competitors. Also, quality assurance. They indicate that the products or services comes from a specific source and meet certain quality standards, fostering that consumers and customers trust. Next up is market differentiation. Now, trademarks differentiate a business's offerings in the marketplace, helping to establish a unique brand identity. And then lastly, legal protection. Trademarks provide legal protection against unauthorized use by others, helping to prevent confusion among customers and consumers and the dilution of the brand's value. Now let's look at the different types of trademarks. Now in business, trademarks can be categorized into several types, each serving a different purpose in protecting the brand identity. Now here are just a few. Number one, word marks. Now these consist of words or letters to represent a brand. Examples include brand names and slogans such as Nike and their Just Do It campaign. Next up, we have design marks. Now these are logos or symbols that visually represent a brand. They can be stylized graphics like the iconic Apple rainbow logo. Next up, we have service marks. Now, similar to trademarks, service marks identify and protect services rather than goods. For example, a logo used by a consulting firm. Next up, we have collective marks. Now, these are used by members of a collective group or governing body or organization to indicate membership or affiliation. An example is the CPA designation for certified public accountants. And then lastly, we have certification marks. Now, these indicate that goods or services meet a certain criteria or standard or even quality, even if the owner does not sell the actual product itself. For instance, the UL logo or the Underwriters Laboratories logo mark for safety standards. And these can be seen on things such as fire extinguishers. Next up, we have trademark registration process. So what does the process look like to get the trademark going? Well, first of all, you have to do a simple trademark search. Before applying, you want to make sure you conduct a comprehensive search to ensure that your desired trademark isn't already in use or registered under someone else. Next up, you want to determine the trademark type. You want to identify whether your trademark will be a word, a logo, or a slogan, or even a combination of these things. Next up, you choose the right classification. Now, trademarks are categorized into different classes based on the goods or services that they represent. So you want to make sure that your goods and service fits in the right classification category. Next up, you have to prepare the application. You want to gather the necessary information, including the trademark representation, the owner details, a description of the goods and services, and the basis of filing. After that, you want to fill out the application and submit your application to the relevant trademark office. For example, here in the United States, we have the United States Patent and Trademark Office. Next up, you want an examination by the trademark office. So after your submission, the trademark office will review the application for compliance with legal requirements. Next up is the registration. Now, if there are no oppositions or if any oppositions are ruled in your favor, your trademark will be registered to you and you will receive a certification of registration. Lastly, you want to maintain the trademark. It just doesn't stop there. So after your registration, you want to make sure that you use all the trademark in commerce, and then you want to file periodic maintenance of the documents. For instance, you want to make sure your renewal application is sent up to keep it active. Next up, what is the actual trademark duration? So how long does a trademark typically last? Now here in the States, a trademark lasts for about 10 years for the trademark registration date. You'll have the option to renew the trademark registration for an additional 10-year period. However, during the first 10-year registration, you must complete an initial trademark renewal between years 5 and 6 to maintain the registration. So you want to make sure you stay on top of it. Next up, let's dive into copyrights. Now, copyrights protect original works of authorship such as literature, music, art, and software. Now, this legal protection grants creators exclusive rights to reproduce, distribute, and display their works, ensuring that they can benefit financially from their creations, because we all want to get paid for the work we put in, right? So lastly, copyrights automatically apply upon the creation of an eligible work, although registration can enhance the protection and enforceability. Now, let's look at the purpose of copyrights. Number one, protection of creative works. Copyrights protect the rights of creators by giving them exclusive control over their original works and content. Next up, you have encouragement of creativity and innovation. Now, by ensuring that creators can benefit financially from the work and get paid, copyrights incentivize the creation of new works and innovations. Next up, cultural preservation. Copyrights also help preserve cultural heritage by protecting artistic expressions, allowing future generations to access and build upon previous works. Next, we have the fair use and access. Now, while copyrights grant exclusive rights, they also include provisions for fair use, which allows limited use of copyrighted material without permission for purposes such as commentary, criticism, or education. Now, let's look at some of the types of works protected by copyrights. Number one, literary works. So, the iconic I Know Why the Cage Birds Sing by Maya Angelou is a literary work. Musical works. Michael Jackson's iconic Off the Wall album, which is my favorite album, of course. It is an example of artistic works and musical works. Lastly, we have Annie Lee's iconic Blue Monday portrait, and this is an example of artistic work. Now, in addition to this, we have software and digital content. For example, Microsoft Office, PowerPoint, and Excel. Now, let's look at the copyright registration process. Number one, you want to check for your eligibility. Ensure that your work is eligible for copyright. You can simply do this by doing a simple Google search, going to the actual copyright office online, and seeing if the work is available for copyright. Next, you want to prepare your work. Make sure your work is fixed in a tangible medium. For example, written down or recorded if it's music. Next, you want to complete the application. Now, you can register your work online through the U.S. Copyright Office's website or by submitting a paper application, snail mail. Now keep in mind that with the online registration, this goes by typically faster than the paper application. Next, you want to provide required information. You want to fill out the application form with details about the work, such as the title, the author, the date of creation, and the nature of the work. Next, you want to submit a copy of your work. Now, along with your application, you must submit a copy or copies of the work you are registering. Next, you need to pay the fee. There's a registration fee which varies depending on the method of registration, either online or paper, and the type of work. But look at it as a drop in the bucket to the money that you can get via royalties. Next, you want to receive the confirmation. So after processing your application, the Copyright Office will send you a certificate of registration if your application is approved. This process takes about several months, so keep that in mind too, so you have to be patient. And then lastly, you want to maintain your records. So keep a copy of your registration certificate and any correspondence with the Copyright Office for your records. Now, what is the typical duration of copyright protection? Now, the duration of copyright protection varies by jurisdiction, but generally it lasts for the life of the author plus a certain number of years. In many countries, including the US, the duration is the individual author's life of the author plus 70 years. For joint authors, it's the life of the last surviving author plus 70 years. Now, for works of hire or corporate authorship, it's 95 years from publication or 120 years from creation, whichever is shorter. And then lastly, some countries may have different terms, so it's essential to consult the specific copyright laws applicable to your jurisdiction. Now, let's look at the legal implications of enforcement. Now, trademark infringement refers to the unauthorized use of a trademark or a confusingly similar mark on goods and services that can lead to consumer confusion about the source of those goods or services. Trademarks protect brand identifiers such as names, logos, and slogans. In addition to that, now copyright infringement involves the unauthorized use of copyrighted material, such as music, literature, art, or software. Now, copyright grants the creator exclusive rights to reproduce, distribute, and display their work. Now, both trademark and copyright infringement can lead to legal action, including injunctions, monetary damages, and in some cases, statutory damages. Now, to wrap it all up, both trademarks and copyrights are essential for fostering innovation, protecting consumer interests, and supporting economic growth. They can create a legal framework that encourages creativity while safeguarding the rights of the creators and the businesses. And with that, I want to close with the references that were used in putting this presentation together. Please visit the websites. Please get online and look at the references. And if you have any questions, please reach out to your United States Patent and Trademark Office or even the Copyright Public Records of the U.S. Copyright Organization. With that in closing, I really appreciate you spending your time with me today. This is Lonnie Vineric Rice III. I hope you gained a little bit of understanding into trademarks and copyrights in the world of business. Thank you for joining me. Take care.